Hi, this is Mortgage Wise with Mike Wise at Capstone Direct Mortgage, and today we've got Jennifer Felten from Real Law. She's the principal there, and welcome.
Thank you.
Thanks for being here. So we're going to be talking about probate today. I know I had a post on my Instagram the other day, and it was about probate, and there was tons of views on it. And so what I want to kind of do is dig a little bit deeper into probate with an expert that actually knows about it more than I do, and we can gain some more knowledge that way. So we're going to get started with Jennifer. So tell me, let's go to the basics. Like, what is probate and why is it there?
Right. Well, it starts with we're all going to die.
So great to have you on.
Welcome, right? We're excited.
Yeah.
And so there has to be a process when someone dies as to what happens with their assets, right?
Okay.
And so probate is the legal mechanism to allow for that to happen. It happens when you have assets, right? So you have to have assets to do a probate. And you have to have not planned, right? So a trust avoids probate. A will becomes part of a probate, right? If your property's owned in joint tenancy or things like that, maybe you avoid probate, but it is the legal mechanism to deal with your assets upon your death if you haven't properly put a plan in place to deal with them.
Okay, so let's talk about, I mean, we're gonna kind of get off topic a little bit, but properly planning means what?
For most people, it's putting a trust in place.
A trust, and the trust basically is a mechanism to make sure that it doesn't go into probate, and it goes to the trustees of the estate at that point in time.
The purpose of a trust is primarily to avoid probate, right? Because you don't want the court and attorneys deciding your fate as to what happens with your stuff.
Okay.
And so you, before you die, make the decisions about what you want to happen. So a trust is actually a quasi-legal entity when you create it, right? So the concept is a revocable trust, right?
Yeah.
So if I want to set up a trust, I do that, but I can do whatever I want with it while I'm alive. Once I either become incapacitated or die, then the trust takes over. It becomes a legal entity, just like an LLC or a corporation, and now it controls what happens with my stuff. So a person is in charge of managing the trust. Well, in a trust situation, it's called the trustee.
Okay.
Right? So the people who create the trust are called settlers, a lot of terms. The people who create the trust are settlers. The trustees are the ones who have authority. Generally, the people who created the trust are the trustees, but when they die, then there's successor trustees, which are the people who have the decision making. And then the people who get the assets are the beneficiaries. The trustees might be beneficiaries, like the heirs, but they don't have to be. Right? And that's one of the things with a trust is you can do whatever you want with your stuff. You can leave it to charity. You can give it to your dog. Right?
I've heard that before.
People do this stuff, right?
Yes.
And you can cut your kids out if you want to, right? But so there's a whole process, and it's about you making the decisions of what happens when you're gone.
So basically, let's bring it back to mortgage and real estate, right? So if I buy a house today, I can take title in my own name. I can take title with my wife.
Correct.
Or I could go into a trust that we created, right? And so we would, when we close, the title is closed in the name of the trust, and that trust will tell everyone where that property is going to go when I die and my wife dies.
Correct. So you actually have trustees of the trust. So a trust actually can't hold title. So people screw this up and they'll put, the Mike Wise Trust.
Yeah.
If the vesting just says the Mike Wise Trust, we have problems, right? Because the trust is an entity, but it can't act for itself.
Yeah.
So it needs to be Mike Wise, trustee of the Mike Wise Trust.
Got
right?
it.
And people get that.
Yes, we
wrong.
do that all the time. So the legal way of doing it, we take care of all that stuff, but the real goal here is that we're talking about planning. If you're planning correctly, then you'll put your property in a trust when you buy that property. Right. So let's say that I buy it individually, right? I'm not married, and so we close on the house, and it's in my name, Mike Wise, and I die the next day.
Right.
that's where probate comes in?
Exactly.
Is that right?
Right. So even as an individual, we like to put a vesting on the title to a property, right? So if you're not married, you might have the vesting of single,
Yeah.
right? Which means you've never been married. You might have the vesting of unmarried, which means you're divorced, or you might have the vesting of widow or widower, which
Yeah.
means your spouse has
Has
passed away.
Yeah.
But that vesting is all that is about succession planning, right? Because if you were married, your spouse already has some level of interest in your property. So knowing what position you're in makes a big difference. But assuming you did it as a unmarried man,
Yeah.
you're divorced, right? Then it would go to probate. There would be no plan. You might have a will that says what's going to happen with your property, but that will still has to go into probate, and the court has to affirm the will and then follow the wishes of the will. Now, what if you had a trust, but you put title in your own name, right?
Yeah.
And you didn't put the property in
there.
the trust. That happens sometimes, often when people refi, right? They had the property in the trust, but then they
Refinance.
and the lender doesn't want the trust to be the
Yeah,
borrower,
yeah,
right? And so
yeah.
they take it out of the trust to refi, and they don't ever put it back in the trust. And now someone dies, right? And the property wasn't in the trust. So we can actually go to the court and ask the court to put it into the trust if we can show that there was this intent. Right? It's called a Hegstead petition in California.
Okay.
Right? And it's based on a case. The first case, the last name was
of
Hegstead.
Yeah.
Right?
They were the
test case.
Yeah.
And these people had intended to be in a trust, but it wasn't. And the court said, yes, it should be in the trust. So the court ordered it back into the trust. It made a huge difference, and it makes a huge difference from a succession perspective, because if I have a trust and it says one thing, that's who's going to get my stuff. If it's not in a trust and it goes intestate succession, which is the government rules for what happens to your property if you don't plan, might be totally different people that get the property.
Yeah, that's a problem.
Right. It's a problem.
So you threw a lot of stuff in there that I kind of want to I want to unpack at least one of those things is that, so I bought the property in my own name. I died the day after we closed, right? And it goes into probate. When does the property actually does the title get transferred? And who does it get transferred to? Right. And who's in charge of that property now?
So a probate title does not get transferred, right? So what'll happen is someone will get appointed authority to act for you in probate. So what happens if I die or you die, right?
Yeah.
Any of us dies,
Yeah.
and we don't have a plan. Someone has to file a lawsuit in the probate court, right? So it's its own version of court, right?
Yeah.
Probate court. We file a request
Okay.
into a petition into the probate court, and they issue a document called letters, right? And the letters are the authority, and they appoint someone to act on behalf of your estate. If you had a will and you would put an executor in the will, generally the court will appoint the executor as the person handling your estate. If you didn't have a will, the person is called an administrator, and the court will appoint that person. Again, someone's going to apply, but someone might oppose, right? Like you got the kids fighting over who's going to administer the
So
estate.
if there was one kid that was there, that's probably going to be okay. But if there's 3, 4, 5 kids, then it's like
you might have a battle over who should get appointed. But the court will ultimately issue letters, and it will say who has authority to act. And the court actually has really broad discretion, so they can give the person what's called full authority, where they can do everything they want to do, or they can give them what's called limited authority. If they give them limited authority, they have to actually get court confirmation before they can sell the house.
The house,
Right? So probate has whole different levels depending upon whether there's disputes or not, what level of trust. Like administrators, sometimes they have to get a bond and post a bond before they can do anything. So it's a thing.
So a couple of things there, right? So there's if you do not have a will,
right,
and have somebody that you are saying who should take care of your stuff when you die, then the court is going to appoint somebody.
Correct.
You may or may not like that person.
Correct.
You may or not know that person,
right,
and they may or not have your best interest at heart. So that's a huge risk on that front.
They don't have a ton of discretion from a practical standpoint, though, right? Like they get to decide on selling the property and all that, but who gets your stuff is very regulated in the code.
Okay.
So if you have a will, your will generally will prevail, though people can contest a will and claim it was invalid.
Right.
They can claim it wasn't you, right? I had a case where my client produced a will and the family disputed that the will was...
He didn't write that will. That was somebody else that wrote it
There
for
was
him.
a dispute over whether it was valid, or there are disputes about whether they had capacity when they wrote it, or whether there was undue influence. Maybe somebody was influencing them to do it. So there are reasons why a will can be contested, just like a trust, right? But assuming it gets upheld, then your wishes will be what happens with your stuff. But if you don't have a will, the code says this is who gets your stuff. And so, for example, if you're married and have one child, your spouse gets half and your kid gets half of your stuff, besides community property, which in California is your married stuff, right?
Yep.
If you have one spouse and two kids, then your spouse gets a third and your kids get 2/3, right? So there's a whole, and if you have parents or siblings.
So it's all kind of written out there and how it
It's
happens.
like 20 layers down.
Okay.
If this, then this, and this, then this. So the government decides what, and so that administrator doesn't get to decide who gets it. They just have to compile it and then distribute it. Right. But someone is going to be doing that.
At the end of the day, the government getting in control of this process is not always the greatest process. And let's go into one more thing that you kind of touched on as well, is that just the length of time that it has to go through, right?
Correct.
Is there an average time for a property or an estate being in probate?
Long time.
That's not an average.
At least a year, right?
Really?
A probate's not going to get done in less than a year.
Okay, so let's, what I want to just communicate to everyone is that if you don't plan, you don't have a trust, you don't have a will, and it does go into probate, then if you have equity in the property at that time, there's a year that could pass by and values of properties change for better or for worse. And so you want to make sure, again, you got a plan, and if you have the trust or the will in place, then you can at least have more control over the process rather than going into the probate side of things.
Well, and someone has to make the mortgage payments, right? During that
Good
time.
point. Yes.
So,
yeah.
you know, there's got to be a system. And if there's no, a lot of estates have assets like illiquid, right? So we talk about something being, a house is illiquid, right? It's not easily turned into cash, right? So if we have a lot of illiquid assets, we may not have the cash to cover expenses and costs. So now the probate process itself is slow and long and expensive. But we can generally get letters issued in a couple of months. So depending upon where you live, like here in Ventura County, we have one probate judge for the whole county.
Wow.
Right? So we're a little, small county.
Right.
And all the probate attorneys know the judge, right? And it's really pretty good. And we can get letters in like 2 months. LA County.
It takes a long time.
You could easily be 4 months just to get letters and then starting that process, right?
Can a lender foreclose on a property that's in probate?
It can. It's hard because the foreclosure process is really slow in California. But if the payments aren't being made, they're going to start that process.
Right.
And where I see it the most is actually reverse mortgages.
Interesting. Yeah.
Right? Because of the way that system works.
Let's see here. On the reverse mortgage, so we can touch base.
The
reverse mortgage. Let's talk about that. So a reverse mortgage is for anybody that's over the age of 62, and instead of you actually paying down your mortgage and paying the loan off, the reverse mortgage, it's like a negative interest. So basically what happens, the interest keeps on accruing on top of your mortgage each and every month, right? Mm-hmm. And then when you die, you have 6 months to sell that property, right?
Correct.
And what I'm hearing you say is that if it's not in a trust, then it goes into probate, and the lender wants to get their money back. They want to sell the property, and so there's a lot of activity that goes on probably in those situations.
Reverse mortgages in particular, because those lenders have a different level of security in the property, right? So
Yep.
traditionally on a mortgage, as long as you're making your payments, you're not going to go into default and have an issue with a foreclosure, right?
Yeah.
But with a reverse mortgage, once the person has died or moves out, right?
Yeah.
Then it's a triggering event for their
For the-
foreclosure
right,
process.
yeah.
So it's a different process. I've had situations where it was a husband and this is a real case. This is a sad case. Husband and wife. The husband had bought the house before they were married.
Yeah.
Right? It was in his name alone. They get married. They did not add her onto
died.
title. Right? And he was elderly. They had a reverse mortgage. He died. And so she's getting thrown out of the house by the reverse mortgage
And
company.
she's 70, 80
right.
years old, doesn't have
And-
anything else.
right.
And
It's really bad.
keep in mind that 2/3 of your net worth, of most people's net worth, is tied up in real estate. And so this is a huge thing that you should be looking at just when you own a piece of property, because if for some instance you got hit by a truck, by a bus, and got in a car accident, whatever it is, and you died, you want to have the ability to transfer that real estate to the people that you want to transfer that to, whether it is family or you're donating it.
Whatever.
Yeah, whatever. You have the ability to basically tell where you want that property to go to. So this is super important. I think at the beginning when we talked about planning, that is the biggest piece of it, and just knowledge of knowing that. In fact, Michelle in our office is like, I don't know anything about probate, so why should I do probate, right? But we need to plan and make sure. What are some of the common problems, mistakes that happen during probate?
Well, I wouldn't say problems. It's a slow process, right?
Yeah.
Because we're relying on the court and dealing with the court process. So first of all, we got to start the process. We got to get the letters issued. That requires notice to any potential heirs and a publication in the newspaper. So we got to go through a process of getting people on notice of what's going on. Then there's a whole process of marshaling all the assets, right? Whatever.
So this is not just real estate. This is like the coffee cup, the kitchen table, the couches,
the stocks, the cars,
right?
the
Everything.
boats,
Yeah.
I mean, there's crazy things, that people own that we have to deal with. All kinds of assets are part of this. And so what happens is the court appoints what's called a probate referee. So that person is like an appraiser, right? And they will value your estate. That is all part of that process. Also, if you have debts, your creditors get to come in to the probate and get paid to go after what you owe them.
Okay.
Right? So an estate can actually end up negative when all is said and done because of the creditors outweighing the assets, right? So that process is slow and time consuming, and you got to find everything. You got to make sure, you have to send letters to the government and make sure that, because if you got government benefits, the government gets paid back.
Social Security payments.
Not Social Security, but like Medi-Cal, Medicaid, like some of those government benefits.
Yeah.
They're entitled to reimbursement when you die, right? So there's a whole process of, confirming who owes what, and the creditors have a certain amount of time to apply into the probate. If there's a will, there can be a will contest, right? And we're fighting over whether, who's entitled to what. And
that's probably the most common one, yes?
Will contests are the biggest hurdles, for sure. Because if it happens, it's very expensive.
Yeah, because and timing, right? And then you get attorneys involved.
A contested will could be 5 years to litigate that kind of a case, right?
Can you dispose of the property? Dispose is the wrong word.
Yeah.
Can you sell the property while in probate just to get the cash into the estate?
Yes. So you can't do it until we have someone who has authority to act, right?
Okay.
Because that person's going to sign the deed, right?
Yeah.
And so the deed doesn't transfer, like I said, but instead they're going to sign as, John Smith, administrator of the Mike
estate,
Wise Trust,
probate,
or estate, right?
Yeah.
And the letters are going to be needed. So in California, we use title insurance, right? So the title company is going to require the letters to show who has authority, and then they're going to have the deed that matches the letters that shows this person had authority to sell, so that they'll ensure title to the property.
Otherwise, title officer is going to, they're going to get this person signing the deed, and they're going to be like, this person doesn't match who's on title to the property, and so forth. So that's, that whole process happens through the probate, right? So at some point in time, somebody on the probate side has to look to the title of the property, who's on title, and then be able to add somebody to sign for those people. So,
and again, with the letters, if they have full authority, they could sell. If they have limited authority, they're also going to need a court order before we can close.
I'm going to go back to kind of, I died the day after I bought the property, right? And now one of my kids is like, oh shoot, there's a lot of equity in that property, and it's going to go into probate. Who do I call?
You need to get an attorney.
Okay.
You can do a probate without an attorney, but what's the concept? The person who represents themselves has a fool for a client. Really, it's worth it to get an attorney to help you through the process. It will go quicker and easier with an attorney. But you also pay for it, right? So the fees in probate are statutory. So California has a set scale of how much, and it's based on the value of the estate. So depending upon how big your estate is how much the attorney
can
is
charge.
going to make. And it's based upon the value of the estate, irrespective of loans. So if I have $1 million house in my probate, but I owe $900,000 on it, right? So I really only have $100,000 in equity. It's still $1 million estate from a probate standpoint.
And that's the fee is going to be charged based on that.
Based on $1 million, because lawyers write laws.
Exactly. Perfect, right? The love-hate relationship with lawyers. Yes. So. Let's just say, again, that I bought the house and I only put 3% down, and I died the next day, and I had, $50,000 worth of credit card debt and so forth, right? So I am upside down. Is it worth it for any of my kids to even go through the process of probate?
Maybe not. Right? And maybe you just let the house go. Right?
Okay. So in that instance, let's just talk through that for kind of as an example, right? The mortgage is not going to get paid. And at some point in time, the mortgage or the lender is going to send notices and say, we're foreclosing, and you're not going to be responding because there's nobody there to respond. And eventually it's going to go to sale. Right? So technically, when it goes to the courthouse steps and it goes to the foreclosure sale, somebody buys it cash. How does it transfer title, and who are because in that instance it didn't go to probate, right? And so what happens?
So a foreclosure supersedes ownership, right? So because we use a deed of trust in California, right, for securing loans. So a deed of trust is a 3-party document, right? The borrower is called the trustor, the lender is called the beneficiary, and there's a third person, a middleman, who is the trustee, right? And that trustee has what's called bare legal title, right? And they have the authority to take over ownership of the property and sell it, right? The trustee has 2 things they can do. They can sell it if you don't pay, or breach any of the terms of the loan, right? You can get foreclosed on for other breaches of the loan terms. Not paying
property taxes
or
whatever.
Or waste, not maintaining the property, right? Things like that. Or if you pay it off, then they release the lien, right? So that foreclosure would wipe out the ownership, whether a probate had been done or not, right? So that it's a higher right because you gave, right? So there are different types of liens. A deed of trust is a voluntary lien. You gave away your power. There are involuntary liens too, like a judgment or a mechanic's lien, where they can do it without your consent. But on a deed of trust, you've consented to give them this authority if you don't perform the terms of the loan.
Okay, I'm going to add one more wrinkle into this, okay? So I bought the property. I died. It got foreclosed on. My kids are basically like, there's no equity in this place and we don't want it, blah, blah, blah. And then all of a sudden, my kids get this check in the mail from an insurance company because I did a life insurance policy for $1 million. And the check's made out to the beneficiary of whoever is on the life insurance, right?
Correct.
So does that go into probate at all either? No. So
No.
because I said I want that insurance to go to my kids.
The life insurance isn't an asset of yours, right?
Okay.
So it's something that you've bought with a benefit that comes with it.
Right.
So and it's tax free, right? So when you actually get that $1 million, you don't have to pay taxes on it. It's one of the few things you don't have to
Wow.
pay taxes on. But it's not an asset, so it couldn't. Like a creditor couldn't go after the life insurance or
Interesting.
things like that. So it's just one of the things with families that I'm always like, you should have life insurance, right? So I got $1 million house, right, and a $900,000 mortgage, and we're making this work because me and my husband are working and making this work. And now my husband passes away, his income's gone. I can't afford a $900,000, right? And now often the widow's left having to sell the house and thrown out because they can't. So a policy to have in place if that happens keeps you in your house, right, and gives you that ability to keep functioning the life that you are used to.
Right.
So there's mortgage insurance for this as well. There are ways to insure for this, and it's something that families really need to think about.
Yeah. We've I've heard a couple of times, a couple of clients basically come back and say, hey, should I get insurance? Should I get life insurance for the amount of my mortgage?
Right.
And
I'm a fan of that.
You're a fan of that.
I am.
Because that way, at least at that point in time,
you get to keep your house.
You get to keep your house. You got to keep on living there and so forth. So
and if you get a term policy, right, there's different types of life insurance, but a relatively healthy 30-year-old person for a term policy for $1 million is probably $10 a month.
Yeah.
This is not like we're talking about millions of dollars you're spending. It's cheap and worth it to cover.
Especially if you're young.
Right.
Jennifer, thank you for coming on. I so appreciate it. There's lots of good stuff in there and lots to learn. You probably want to listen to this more than once because she's got a lot of words in there to talk about this, and you got to follow along. And so this is Mortgage Wise with Mike Wise at Capstone Direct. Subscribe to our Mortgage Wise YouTube channel and you will get notified when more videos come out.